Can you hear me now? Waiting for stuff. Are you able to hear me now? Fuck. Oh. I was waiting on the delay and thought I was still muted. Okay. That's what I get for changing settings right before I go live. But yeah. That's what I get for coming back to Delete Lawz after I was done with him. So when I was muted, I get the reference. Yeah. While I was muted, I was saying, I'm back, but I don't want to be back doing this because I got bored of Delete Lawz a long time ago. And but he's like athlete's foot. You just can't get rid of him. And I stopped covering Decastro versus LVMPD. I stopped with the Decastro versus Peter, the LA case. But that one wasn't so much boredom as, I'm not a California attorney. California state court is weird. And I didn't feel I could competently speak about it, at least not to the level I wanted to. And so, yeah. But we have a brand new Groundhog Day lawsuit in Massachusetts. And so, yeah, Hodgepodge Harmony, it is a new filing, a brand new lawsuit brought by Delete Lawz. And floor to top bunk. Okay. I always, one of the reasons I always sucked so bad at German is they have the combination words where, if we don't have a word for something, we'll just take a bunch of words that put together have that meaning and stick them all together as one word. And I always sucked at that. I like spaces and words, but yeah. Either way, I appreciate you sending out the bat signal. And Jennifer Ray, Karen Reed, I said at the end of the first trial, when we got the hung jury, I said it then and there that I wouldn't stream it again because that was brutal. Once is enough. I actually thought at the time that I would watch it, but I couldn't. I just, the thought of it gave me a visceral, like, ugh. And so I have studiously avoided it. And I am happy with that decision, even though that leaves you with very few lawyers on YouTube who are covering it that are not on Karen Reed's side, unfortunately. And so, yeah. And basically, Hodgepodge, that's like, I told my mom earlier this evening, guess what I'm doing or going to do. And I said to her, I think he needs the attention. He's become so irrelevant that, hey, maybe if I sue, it'll get people talking about me again. And, mea culpa, here I am. But, yeah. And yeah, Handschuhe is one of the shorter German combination words. And it, yeah, just from glancing at this so far, Corrosive, the whole thing is a train wreck. It's it's awful, like worse than usual. And Rusty, good to see you. So I've blathered long enough. I've been gone long enough that I don't expect YouTube to push this out to many people. So it's going to be a small affair tonight, but I realize I'm also going live at 10 o'clock Eastern, but you know, it's only 8 o'clock where I am. So yeah, so let's go. This is not entirely deja vu because this is titled Decastro versus Hiller. And Hiller is the YouTuber, former Decastro friend, I think, because frankly, I've never watched him. But this is Lackluster. Frankly, calling this the Lackluster lawsuit, I think, is accurate. And it's, yeah. And, yep. This is all it takes to bring me out of hibernation, Brandon. Just file a new frivolous lawsuit, and here I am. And so we are back in the district court, federal district court for the District of Massachusetts. And thus far, we have a complaint filed June 3rd, 2025. And so that, as of now, that is yesterday, 2 days ago for you, CJ5, but that's because you're in the upside down. And that's going to be a problem for him. Spoiler alert. And once we pull up the complaint, I'm a little confused. I mean, I'm a lot confused, but I'm a little confused procedurally how we got here based on his caption and formatting. I'll explain it in a second. But even in spite of my confusion, it appears that, you know, he filed the complaint himself in federal court. It appears he paid the $405 filing fee. So it's not a mistake we're in federal court, except I didn't actually want to show the entire caption. Except Commonwealth of Massachusetts, First District Court, Boston, Massachusetts. It's captioned for state court. So it's captioned for state court. Did I legitimately don't know. Did he file something in state court? Did like procedurally looking at the docket that this hasn't been removed to federal court? He filed it here, but it's captioned for Massachusetts or for federal court. And that said, though, this is an abomination of formatting. This does not follow any of the formatting rules for federal court. It's single spaced. It's ugly. It's awful. And and as we can see, it's stamped on the complaint filed 6/3/25. It's possible that he filed by mail, and so he mailed it earlier. That might be the only thing that ends up saving this lawsuit. But I have my doubts. We'll see. But either way, it is, let's see, and then it also has a stamp, a physical stamp on it, filed June 3rd. And it is Jose Decastro versus Dale Hiller, aka Lackluster, Joshua Abrams, aka Accountability for All, Kate Peter, aka Masshole Mafia, and John Doe's 1 through 5. He's not as ambitious as he used to be. In the past, it was Doe's 1 through 50. He's only got 5 to go after now, and he is out of jail. He's been out of jail for a while, like a year. He Judge what's her name? The Vegas district court judge overturned it on appeal, which was the wrong decision. I don't think she had the full facts, but either way, he still spent most of a 6-month sentence in jail, even though it was overturned. That's still not going to be enough for him to win his civil lawsuit in Vegas. But yeah, as far as I know, he's out of jail. And like, I don't follow him. So unless he's gone back, I think he's out. But this is a complaint for defamation and false light. Now, why have I been making a big deal of the date it was filed? Because, let's go, this is mass.gov/info, details, Massachusetts, law about defamation. And Massachusetts General Law 260, Section 4, Statute of Limitations. Actions for slander or libel shall be commenced only within 3 years next after the cause of action accrues. And kind of, but kind of not. And in Lackluster's case, definitely not, but we'll get to that. So 3 years for defamation, same for false light. I looked it up, but I'm not going to pull it up again. And while we're here, let's see. Let's see. Extending time. Let's see. Summons. I should have looked this part up earlier. It doesn't matter, because frankly, I don't care. I'm so sick. I'm so sick of this idiot. Yeah, I don't care about extension of time. It's possible. I don't even know, because frankly, I don't do civil. I don't do federal court. I just it's never been an issue for me. I learned about deadlines and extensions because of mailed in service and yada yada. But I'm a lawyer, so I just do it. I do it electronically. I wouldn't do it by mail, so I don't care. But either way, JT Davis, good to see you, and Sri. So why? Let's just read this abomination. Here's the thing, CJ5. Is Kate going to answer this? I have no idea. Her strategy in the LA case was ignore it. What's he gonna do? And I have the feeling she's going to take the same attitude here. Josh, I have no idea. I dislike him every bit as much as I dislike Delete Lawz. But when you're in the right, you're in the right. And in this case, Josh is in the right. Dale, I have a feeling I wouldn't be his biggest fan, but I have never watched him at all. I have no idea. It's just, it's all nonsense. It's complete and utter nonsense. It's what else is there to say? But let's look at just how bad the nonsense is. So, complaint for defamation and false light. Plaintiff Jose Maria Decastro, appearing pro se, brings this complaint against defendants Joshua Abrams, Dale Hiller, Kate Peter, and John Does 1 through 5, and alleges as follows. Plaintiff Jose Maria Decastro is a resident of California and a public constitutional rights advocate known online as Delete Lawz or Chili. Defendant Joshua Abrams, also known as Accountability for All, is a Massachusetts resident who hosts and publishes content through a YouTube channel with approximately 238,000 subscribers. And that's a good point. That's a good point, JT. We do need to look at the date of the live stream when it aired, and that's a good point that I didn't bring that up yet. It is, I can't highlight apparently, but it's June 1st, 2022. So it is 3 days or 3 years and 2 days before the filing. It is, frankly, it is vague, but at the same time, it's what he says is taken for the purposes of this pleading. It's taken as true. So by his pleading, it took place on June 1st. So yeah. Oh, okay. Defendant Dale Hiller, known publicly as Lackluster, is an online video producer with over 1 million subscribers. He resides outside Massachusetts, but regularly broadcasts content to a nationwide audience, including into the Commonwealth. Yeah! Okay. This is this is a case that I am way behind on. Well, what am I? I'm way behind on this case, but Braun v. Day. Just to give you an example, of why I went, yeah. If the search ever wants to complete. Okay, Braun v. Day. This is Janet and Lauren the Mortician versus the Girlies. This is the complaint from Janet versus the Girlies. And hey, in the parties. Upon information and belief, defendant Jessica Vasquez is a citizen and resident of a state that is neither Illinois nor Florida. Upon information and belief, defendant Vasquez is a victim of certain crimes, and out of respect to her privacy, plaintiffs request to not directly plead Ms. Vasquez's current state of residence. So, for those of you who have followed my coverage, I know I'm way behind, but those of you who have followed Janet versus the Girlies, the judge said, yeah, that's not going to work. I understand you're trying to, recognize her past traumas, even though she is very open that she lives in Georgia. Like, she says it on her own streams, but you have to, to get a diversity jurisdiction lawsuit into federal court, you have to say where they are domiciled. In fact, Janet didn't even do a good enough job for herself. If I remember right. Or maybe she did. Maybe I'm just not remembering right. But either way, it's just, here we have Delete Lawz. Yeah, so Lackluster doesn't live in Massachusetts. Well, that's not relevant. That's not relevant. I mean, yeah, for the long arm statutes, in order to say, yeah, so he committed a harm in Massachusetts, the, broadcasts reaching Massachusetts might matter. They might not, but we'll see how he pleads it. But either way, him residing out of Massachusetts, you have to say where he resides. Because if he resides in California, guess what? There is not diversity. Diversity explodes. And case dismissed. As it is, diversity doesn't exist because you have not sufficiently pled diversity jurisdiction. You're going to already, right out the gate, you've blown your load as far as your gimme, the amended complaint. I can't even think of the right words because the level of stupid we're dealing with here drags me down with it. But he has blown his load. He has to amend the complaint right out the gates in order to even have diversity jurisdiction. Because defamation and false light are not federal claims. They are state common law tort claims. In order to bring state claims into federal court, there has to be a jurisdictional hook. In this case, that's diversity jurisdiction. For those of you who are new, it's fuck's sake. For fuck's sake. Just reading ahead, you can tell I didn't read this stupid thing. See, I did it because if I am here, you have to imagine Chili blowing his load. It's your punishment for me being here. But I didn't read through this, as you can tell. I literally looked at the dates and I looked at the causes of action to check the statute of limitations. That's all I looked at. But it gets worse as we continue. The reason I looked ahead is I'm like, well, maybe the federal law section for diversity jurisdiction, it should be pled on the complaint. It should say this has diversity jurisdiction because of this. Because of this section. And I can't remember the title. I think it's section 1367 or something, or I can't remember off the top of my head, because it's not, lawyers, we don't remember things off the top of our heads. We look them up. But, and so that it stops bothering me. Federal diversity jurisdiction and Title 28, Section 1332. So for a court to exercise diversity jurisdiction, and for a court, that means federal court, the amount in controversy must exceed $75,000 and complete diversity of citizenship must exist. Complete diversity means no one on the plaintiff's side of the V can reside in the same state as anyone on the defendant's side of the V. Now, if multiple defendants live in the same state, that's fine. You still have complete diversity. If multiple plaintiffs live in the same state, that is fine. You just can't cross streams. That was for you also, Svi. So the fact that Kate and Josh both live in Massachusetts, I assume Josh still does, is irrelevant. It doesn't matter. The fact that Dale doesn't live in Massachusetts, as long as he doesn't live in California, that's fine. But Chili has to say where he lives. And the thing is, Rusty, he's gotten worse. This is by far the worst I have seen. It's like Richard Leibowitz, like, I don't know that I've actually ever seen one of Leibowitz's pleadings. I've only seen Leonard French cover Leibowitz. But Leibowitz wouldn't do an abomination like this. He just wouldn't show up. Chili doesn't show up either. So, but yeah, so defendant Kate Peter, Catherine Peter, thank you. Use her actual name if you're going to sue her. Known publicly as Masshole Mafia and Troll Mafia official, is a Massachusetts resident who hosts a YouTube channel with nearly 38,000 subscribers. Defendant John Doe's 1 through 5 are individuals whose identities are presently unknown, but who participated in, contributed to, or promoted the dissemination of the defamatory statements described herein. Jurisdiction and venue in this court are proper in this court pursuant to Massachusetts General Laws, Chapter 223 and 223A, subsections 3C and D, because defendants intentionally directed their defamatory conduct into Massachusetts and caused harm therein. Abrams and Peter are Massachusetts residents. Abrams hosted the defamatory live stream from Boston, and plaintiff was present in Boston with Abrams just days before the broadcast. The broadcast targeted Massachusetts audiences and involved Massachusetts-based conduct and individuals. You can't sue in federal court based on Massachusetts General Laws, Chapter 223 and 223A. Those are not a valid basis for jurisdiction in federal court. Like, as I said, unless he filed in Massachusetts state court and it was removed to federal court because they said, yeah, we don't have jurisdiction. There you go, feds. But that would be number one on the docket. The number one thing on the docket would say, yeah, so this was removed from state court. It's ours now. Here's the complaint. That's not here. He filed it in federal court. He filed in federal court. He paid the $405 filing fee. I mean, he's as dumb as one. I mean, I don't know why anyone would like Josh. He's an abominable person. He's awful. He's absolutely awful. But when you're right, you're right. And in the case, in the right, I should say. And Josh didn't defame Delete Lawz. He did not defame Jose Decastro. Jose Decastro is just a big crying baby that needs to run to daddy court to protect him. And yeah, but I'm a 20-year constitutional law scholar. I barely graduated high school, but I sure knows me some constitutional law. I mean, if a complaint had a sound, that's what this complaint sounds like. I just like I don't know why he did this. He's too stupid to realize that he wrote this for state court and filed in federal. Like, was the federal filing an accident? But it can't be an accident because he paid the $405 filing fee. Did he prepare this for state court and change his mind, but not change the document? Was he just running out of time and didn't have time to fix it? Like, yeah. Yeah. He's a statist crybaby. And which Mel Blanc character are you thinking of? Did he do, like, did Mel do, like, Huckleberry Hound? Or, like, because obviously I think of Mel Blanc as Bugs Bunny, Porky Pig. But, you know, he's the man of 1,000 voices. I assume he did. Who did Foghorn Leghorn? Was that also Mel? So, and I mean, he presumably is at least a limited public figure. He's gonna have to prove defamation per se. He's going to have to prove actual malice, and that's really fucking hard to do. Ah, okay. Good to know. Even though I'll forget it before the end of the stream, because, yeah. But this is bad. This is bad. So, and I really don't want to go back and figure out the date of the stream, because I don't like going to Josh Abrams' page. And frankly, so on or about June 1st, 2022, just after Memorial Day, defendants appeared in a live stream video hosted by Defendant Abrams, in which they made numerous knowingly false, defamatory, and malicious statements about plaintiff. And now I'm curious. Let's hop in the time machine and go all the way back. May 2022. First Monday, second, third, fourth. Is Memorial Day the fourth Monday, or is it the last Monday? Does it follow Thanksgiving rules, or just last Monday? Because it was either May 23rd or May 30th. For some reason, the time machine doesn't label holidays. How obnoxious. But either way, I'm not making any factual statements about Delete Lawz. I am giving opinion and commentary on the lawsuit. Okay, that's what I thought. That's what I thought the last Monday. I don't know why I got in my head that it's Thanksgiving, but it's the last Monday. So the 30th. But either way, on or about June 1st, just after Memorial Day, that's irrelevant. That like, if Memorial Day is relevant, give the date. Say why it's relevant. So during that live stream, Defendant Abrams made several specific and maliciously false claims. He falsely alleged that plaintiff strangled someone. Abrams then stated that plaintiff went to a friend's house in New Hampshire, kicked his friend out, told him to go stay in a hotel, and then used the home to do drugs. Abrams claimed that the friend returned at 6 a.m., found drug paraphernalia scattered throughout the house, and then kicked plaintiff out. He also accused plaintiff of creating fake app screen designs referred to as pillow poppers in collaboration with his cousin in order to fraudulently obtain a large investment from an investor. Abrams additionally accused plaintiff of blackmailing people. Each of these allegations is completely false and defamatory per se. I like it being 3 years ago, although, as Corrosive said toward the beginning of the stream, how is it only 3 years ago? It seems so much longer than that. But I don't have facts. I'm not making allegations. What? Why would I make allegations? I'm just giving commentary. And so a lot of them are, but we may as well pull it up now. Let's see. Let's search Decastro versus Abrams. And I guess while I'm waiting for the search to complete, since I forgot to introduce myself at the beginning of the stream due to being muted, I'll introduce myself for the benefit of Aaron. Hi, I'm Joe. I'm a lawyer licensed to practice law in the state of Utah. I give legal commentary. I don't make factual assertions. I give legal commentary. I talk about the law. I talk about what the law actually is. I talk about the application of the law. What do you do? Does he have an... How does he spell his name? Huh. Oh, that's what I did wrong. I did DA. So, looking at the original complaint in Decastro versus Abrams, so no. So from January 2022 until May 22nd of 2022, they defamed him. So the May 22nd, 2022 video and the June 10th, 2022 video and yeah, so basically what I think he's done is he so if you recall the procedure, and I'm just gonna get rid of Aaron because he annoys me and I'm like that and I'm too easily distracted and frankly, yeah. But so if you recall the procedure from this case, because it was a long fucking time ago. He sued for defamation. Then Kate and Josh answered. They filed answers. Right after they filed answers, Decastro said, "Oh, but Judge, I sent in a notice of voluntary dismissal so that I could dismiss and then file a new lawsuit." And so that was the whole nunc pro tunc saga, saying, "Judge, let's go back in time and actually dismiss it," before they filed their answers, and I could no longer voluntarily dismiss it without their permission. So he thought, hey, here's a brilliant workaround because, the courts, they'll never see through this, and I'm going to file an amended complaint. But the amended complaint is going to be for defamation. Therefore, I have dismissed those claims through the back door. And so they're voluntarily dismissed without prejudice, and I can file them again. Well, I haven't looked up the law on that because I don't care to. It doesn't matter because he's not actually suing on those. But courts do not do fuckery. Like, literally, if I couldn't, number one, I wouldn't expect a opposing counsel to play those games. But if they did, or if I had an opposing pro se play those, and I couldn't find case law on it, because, there might not be case law on it. I don't know. I'd literally say, look, Judge, he could not have dismissed those claims without my permission. This is an absurdity if you allow him to have dismissed them without my permission. So they're dismissed with prejudice. You've got to do it. And, would the judge go along with it? Probably, because they don't like fuckery. So, but either way, the May 22nd video, that's right out. Because, even if we have a calculation of days due to mailing in the complaint, that it's definitely not a 12-day look back. At best, it's, but I believe it's 2 days. But it doesn't matter. Yeah, probably. And that's the one I meant to click on. Neil, good morning there in Scotland. I'd say it's too early, but that's about when I'd be going to bed. So it's, but yeah, but then the June 10th video is, he's still got 6 days on that statute of limitations, but still. So what I think he did is he went back and he said, well, what's a video I didn't actually sue on? Even though it's, I'd argue it's all part of the same transaction or occurrence. It's, I don't actually know, because once again, I don't play fuckery. If I'm going to sue for defamation, I'm suing for all of the defamation. I'm not going to say, yeah, I'm going to sue for these 2 streams, and if I lose, then I'm going to come back on the 3rd. That's amateur shit. So it all looks like the same transaction or occurrence to me, a series of live streams. But it doesn't matter, because they have other means to get it dismissed. As of right now, we have lack of jurisdiction. We have failure to state a claim upon which relief can be granted because it's after the statute of limitations, probably. And I don't actually know if I watched Josh's live stream at the time due to my dislike of him. And so that might be why a lot of these allegations I'm not remembering. Because I remember at the time, Kate did go on a few live streams on Josh's channel. Josh did some live streams on Kate's channel. And I do remember, I did watch those. I don't remember if I watched the ones on Josh's channel, and it's possible I didn't. And so I'm literally not here worried about the factual allegations here because I don't remember and I don't care to go back to watch. I do not want to go back and watch because I don't like Josh Abrams, as I've said. But like investment, fraudulently obtaining large investments from an investor, I'm sure that's either to do with Coded Friends or JockSock or what are the others? There are a couple of failed enterprises on his behalf. And frankly, if he took investor money and didn't register the security, because even private sales of securities, you have to register. Even if they're exempt, you have to file an exemption from registration, such as the Jobs Act, such as Reg D, Reg A. It's all in the securities laws. I don't remember enough about them, like, to say which one these would fall under, because, well, frankly, I don't know enough about what he did. I'm assuming he didn't get very much at all. So, but like way under 50 million, which is generally the threshold for having to register a security. But yeah. Oh, yeah, there was a transparency app. And then there was also the one that he had a similar idea to Long Island Audit's app that Long Island Audit's actually, I believe, has released, as big a waste as that is. But yeah. So, but yeah, getting back, number 9. These statements are categorically false. Declarant A military veteran and hedge fund manager who resides in New Hampshire and hosted plaintiff at the time, has submitted a sworn declaration refuting the entire story as fabricated. Declarant B, a technologist and U.S. military veteran residing in Phoenix, Arizona, and plaintiff's cousin, has submitted a sworn declaration confirming that no app fraud occurred. The names and identifying information of declarants A and B have been redacted to protect them from online harassment, doxing, and business retaliation by defendants and their associates. Full unredacted versions are available for in-camera review by the court upon request. Yeah, couple issues here. Number 1, this is federal court. You don't submit declarations from third parties with your complaint, because your pleadings in your complaint are for the purposes of the complaint taken as true. You don't need to bolster that. But then even still, submitting anonymous declarations. That shit ain't gonna fly. It, like, file it under seal. Ask the court for permission. This doesn't work. But it's also it's unneeded. It's a waste of space. It's a waste of bytes on the computer. But the once again, I am a Utah-based attorney. I am not in Massachusetts. I have never practiced in any court in Massachusetts, especially state court. Not federal court either, but definitely not state court. Now, federal court is going to have the same rules of procedure. It's going to have basically the same court rules. Now, the local rules are always a little different, but they're generally pretty similar. State courts are wild. Now, if you recall, in California, what does MERB call it? California has fact pleading, where you have to put the actual facts in your pleading. You've got to have backup in your complaint. You've got to have the declarations. Is my understanding. Once again, I am not a California lawyer. That is based on MERB. MERB 34th Street. He's a California lawyer. He knows what he's talking about. He also has a YouTube channel, so if you're here, you probably know who he is. It's possible state court in Massachusetts, because remember, this talks about Massachusetts State Court. Its caption says Massachusetts State Court. Massachusetts State Court might also be fact pleading. It might require declarations. I don't know. I don't care. But that might be why they're there. We will be charitable to Delete Lawz and say that is why they are there. But that being said, even the Massachusetts state courts would treat them as if they are not there because they're improper. They're anonymous. They're anonymous. And they, like, at least the one from the hedge fund manager, presumably, it doesn't even need to be anonymous because, like, Kate would know who it is. Delete Lawz would certainly say Kate knows who it is because, if you remember, part of the fuckery he alleges in the California case is Kate went to the New Hampshire property and left a sign, and Kate always wins or something like that. And so why the need for anonymity in a public court if your opponent, by your own logic, already knows who it is? This is just, it's chilly logic. That's all it is. 10. Abrams also, oh yeah, and so Defendant Abrams made those statements. Defendant Abrams also accused plaintiff of using his credit card without permission to pay for a hotel room, presumably Abrams' credit card. This claim is demonstrably false, as evidenced by plaintiff's bank records attached as Exhibit D. Plaintiff paid for the hotel stay with his own funds, $306.06 on May 29th, 2022, and $85.74 on May 30th, 2022, both at nights in Danvers, Massachusetts. Additionally, plaintiff sent Abrams $205 via electronic payment on May 28th, 2022, with the note, "For thanks, man," showing that plaintiff had already reimbursed Abrams prior to the alleged incident. It's categorically false that I used his credit card without permission. See, here's evidence that I didn't even use his credit card, but I also reimbursed him for the use of his credit card. Why had you already reimbursed Abrams prior to the alleged incident if you paid for everything yourself? Why did you reimburse for something you already paid for? It doesn't make sense. It's absurd. Remember when Kate called him a quarter of a man? He only has a quarter of a man's brain. He is dumb. D-U-M, dumb. So dumb, he doesn't deserve the B when I spell out dumb. These records demonstrate that Abrams knowingly made a false accusation in an effort to malign plaintiff's character and credibility. This constitutes defamation per se and supports a finding of actual malice. Abrams also edited video footage of plaintiff's interaction with defendant Kate Peter in a misleading way. He removed critical context showing that defendant Peter stepped on the back of plaintiff's shoes, which caused plaintiff to lean backward defensively. Abrams presented a slowed down version of plaintiff's reaction, making it appear aggressive. In the same video, Abrams stated, "All I'm guilty of is pausing the video," downplaying the extent of the edits. This misleading presentation distorted the truth and contributed to the negative public perception of plaintiff. Except we have Kate's live stream too. That mean lady has boobs, and I elbowed her in the boobs, and that hurt my feelings. Fuck's sake. Defendant Hiller stated, now, was Hiller on the live stream? Like, I mean, clearly I must not have watched this live stream because I honestly have. I don't think I've ever seen Lackluster in anything. So I doubt that I did watch this live stream. It must have only been Kate's that I watched with Josh on. But did both Kate and Lackluster do the same? Were they both guests on this live stream on Josh's channel? And yeah, I mean, that's it. He's defamation proof as it is. His own actions are why people dislike him. And yeah, and the thing is, like, he touched Kate's tit through her shirt. It probably, if his mom breastfed, it was probably through the shirt too. Like, I mean, can you really hate a baby? I imagine this baby was pretty hateable. Like, I mean, I'm just guessing, but yeah, Defendant Hiller stated, "There are victims. There is proof of it. That's all I can say for now. Hopefully more will be revealed." This deliberately vague and ominous assertion strongly implies that plaintiff has committed violent acts against others, potentially including physical abuse toward women. While Hiller did not specify the nature of these alleged victims, the statement, in the context of surrounding commentary by co-defendants and the video's framing, invites the viewer to draw the false and damaging conclusion that plaintiff has engaged in violent criminal conduct. So what you're saying here is, let me get this straight. Well, Lackluster, he alluded to defamation. He didn't actually defame me, but a listener could interpret it as defamation, I guess, kind of, if you take the contextual clues. So it's vague? It's not defamation? You say right there it's not defamation? Fuck's sake, he's bad at this. Like, I'm not surprised because he's always been bad at this, but how did he get worse? Like, did they turn off ChatGPT legal help? Did he alienate Baby Lawz or Bobby Lawz or whoever the hell else he had ghostwriting unauthorized practice of law? Yeah. All those restraining orders that are on the record, those are all false. Well, no, Kate just pulled up the wrong restraining orders. Yeah, it's the same name, same date of birth, same address, but it wasn't me. It was never me. Well, yeah, my ex-girlfriend was so afraid of me that she kept renewing the restraining order for years. But I don't have any victims. He's just... Given that defendant, Kate Peter, was the primary target of plaintiff's verbal interactions in the video, and Hiller appeared in her defense, his statement further suggests to the audience that plaintiff has a pattern of aggression toward women. Although the statement was broadcast on the Accountability for All channel and not on Hiller's own platform, Hiller made the statement publicly, with full knowledge that it would be disseminated to a wide audience. His participation in the broadcast and his deliberate insinuation that plaintiff has harmed unnamed victims constitutes defamation per se. It was made with reckless disregard for the truth and with clear intent to damage plaintiff's reputation. Plaintiff contacted Defendant Hiller on 3 separate occasions to request a public retraction. Hiller refused to retract or amend the defamatory statement. Defendant Kate Peter stated he also employs blackmail and extortion and threats a lot, and further alleged that plaintiff operates a Ponzi scheme. She described this supposed scheme as one in which plaintiff solicits funds from new investors to pay off previous investors, suggesting criminal fraud and financial deception. Peter made these allegations without evidence or due diligence. She continued by speculating about plaintiff's criminal history, despite admitting that she had not verified the claims. These statements were intentionally designed to portray defendant as fraudulent, threatening, and morally corrupt, and they constitute defamation per se. But you have a criminal record. You've admitted to it. Well, I only have misdemeanors, so I don't have a criminal record. Misdemeanors are a criminal record. Charges are part of your criminal record. It's a criminal record. You have a criminal record. I mean, at least assuming that the records Kate showed that she pulled from public sources, you've admitted to them. Well, you know, when I was in jail doing, working out with black guys and da-da-da-da-da, why were you in jail without a criminal record? Huh. And like I said, I probably didn't watch this live stream. If I remember, Victor, good to see you when you catch up. I bet everyone who's been watching live wishes they could have been catching up on 1.5 speed. So you're the lucky one. Sorry. From the streams I did watch, Kate didn't say, "Oh my God, this is a Ponzi scheme." She said, "This looks like a Ponzi scheme." That's her opinion. Opinion is protected speech. You'll notice this is not a direct quote. She further alleges that he operates a Ponzi scheme. She described this. Give us the damn quote. If you don't give the quote, it didn't happen. These are bald assertions of fact. These are conclusory. Well, what was that? What was that? The crying in court in Vegas? The clip that Mike uses all the time? Because, in fairness to Delete Lawz, that one is after 2022. And I am fair. But I was working out with the black guys. He didn't say black guys. Yeah, that was way before. So yeah. And Goosebump, good to see you. And now you're stuck in the slow lane with everyone else. Yeah. So these accusations were made to a large audience through her YouTube channel, Troll Mafia Official, formerly Masshole Mafia, and were intended to cause reputational harm to plaintiff and alienate him from professional networks and public credibility. Wait. Hold the fuck on. The dumbering continues. That's a reference to another Law Talk with Mike clip. I want to dumber down the ticket. But We're on 15. So, on or about June 1st, 2022, just after Memorial Day, defendants appeared on a live stream hosted by Defendant Abrams. These accusations were made to a large audience through Kate's YouTube channel, Troll Mafia Official. So when were they made? When were they made? What video was it? It wasn't on Abrams. It wasn't on June 1st. So was it the... Is he trying to get around the May 22nd video? Is he claiming this is the May 22nd video, but it's so far beyond the statute of limitations that he's going to pretend, well, yeah, Kate made these accusations on her channel on June 1st on Josh Abrams' channel? What fuckery! He's as dishonest as the day is long. Like, seriously. What video is this you're talking about? You have to plead. You have to include that. This, like, you're not putting Kate on notice what you're suing her over. Which video? Like, this is not a claim upon which relief can be granted. Kate can't defend herself against this. So, like, as far as Hiller and Abrams go, the statute of limitations probably applies. Unless he mailed it in, then it maybe applies. But with Kate, we have no idea. Like, we literally have no idea when the statute of limitations expired on his claims against Kate, because we don't know what he's suing her over. Is this the May 22nd video? Like, I if I remember right, I've titled a video about him in the past that is Delete Lawz the dumbest quarter of a man alive? Answer, yes. Yes, he is. This, like, if I had filed this as a lawyer working for a law firm, I would be fired. It's that bad. Like, this isn't just oh, yeah, it's not great, you know, amend it and do better. No, I would be fired for this. Any lawyer would be fired for this. Now, he's not a lawyer. He's not a legal scholar. He generally doesn't know what he's talking about, at least from my observation. As you know, I don't watch Delete Lawz. I find him tedious. But this is bad. It's really, 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 really fucking bad. In addition to the foregoing, defendant Peter falsely claimed during the live stream that plaintiff has multiple liens filed against him. This statement was made without any supporting documentation or investigation and was intended to portray plaintiff as financially irresponsible and legally compromised. In truth, plaintiff has no such liens. This false statement further contributed to the damage of plaintiff's credibility, trustworthiness, and professional relationships, and constitutes defamation per se. Now, frankly, I don't remember that claim on Kate's part. Did she make it? I don't know. I don't remember it. But you'll notice Kate falsely claimed that defendant has multiple liens filed against him. Plaintiff has no such liens. Now, those were both present tense. Now, you say you have no liens. Did you used to have liens? There's a difference. Your statement that you have no liens can be true, while also Kate saying you had liens can also be true. You clearing up the liens in the 3 years since can make both of those true. And Corrosive says, if he recalls correctly, Kate actually found liens. And like I said, I don't know. I legitimately don't know. I don't remember. It's 3 years ago. And I don't have recollection of her saying it. I'm not saying she didn't say it, and I'm certainly not saying she didn't find them. But yeah. Well, I can answer this, Church of POS. Chili was supposed to be doing an apprenticeship with Michael Aline, so how does Chili's lawsuit writing get worse instead of improve? Well, the answer to that is, assuming he was doing an internship or apprenticeship with Michael Aline, the way it got worse is because Michael Aline is an idiot who doesn't know what he's doing. He has no business being a lawyer. So, and to my knowledge, the only warrant I know of is the Ironton warrant. Because the one with, was it Great Lakes audits? They resolved their differences, is my understanding, and that one's gone. There might be others, but I don't know. And that's possible. That's possible. A lien was filed. He got rid of the property. Therefore, her saying there's a lien, but that just means there was a fraudulent transfer of property. If that's what happened. I'm not saying it is. I'm just saying if that is what happens, it would be a fraudulent transfer of property that could, in theory, be clawed back by the lien holder. In theory. Or they could just, in theory, lien other property, depending on what type of lien it is, and it doesn't matter. But Defendant Hiller has previously been sued for defamation in the case of Getz versus Hiller, filed in the U.S. District Court for the Northern District of Illinois in 2024. In that case, Chicago Police Sergeant Ignatius Getz alleged that Hiller falsely identified him on social media as the officer who had made an obscene gesture during a protest. The lawsuit alleged defamation and related claims. The case concluded with a settlement in which Hiller agreed to a financial resolution, and the court retained jurisdiction to enforce the settlement terms. This demonstrates that Hiller is aware of the legal boundaries regarding false and defamatory speech and supports the conclusion that his conduct toward plaintiff was intentional and carried out with actual malice. You can't use other lawsuits as evidence that you were defamed. That's completely irrelevant. That is inadmissible. You can't do that. But even still, it was filed in 2024, 2 years after 2022. So you're saying, well, he was sued 2 years after he allegedly defamed me. So he should know not to have defamed me 2 years before he was sued for defaming a cop. The logic ain't logicking. Like, like, even if this were an appropriate thing to plead, there's no logic in it. It's like, well, yeah, Lackluster knows now, but he didn't in 2022, potentially. Besides which, it's like, well, this one, he crossed the line with Getz, but that doesn't mean he crossed the line talking about Decastro. That, you know, this is 1 plus B equals kangaroo. Like, and yes, I said kangaroo because CJ5 was the last one to comment, and each defendant acted with actual malice, or at minimum, reckless disregard for the truth. Their statements were designed to humiliate, discredit, and destroy plaintiffs' professional and public standing as a First Amendment activist. The defamatory statements constitute defamation per se under Massachusetts law because they accuse plaintiff of crimes, immoral conduct, and professional dishonesty. As a result, damages are presumed. I could be wrong here. Once again, I've never tried a defamation case. I've only given YouTube commentary about it, but damages aren't presumed. Like, even in defamation per se, harm is what is presumed. The injury is what is presumed. You still have to prove damages. Like, you literally, the court can say, all right, yep, that's defamation per se, you win, here's $1 and a squeaky toy. Like, that's all they have to do. Because you still have to prove damages in order to collect damages. So stupid. I just... The transcript cited herein was produced from the original live stream video hosted by Defendant Abrams and preserved by plaintiff with complete metadata and timestamp integrity. Plaintiff is prepared to submit the video and full transcript for judicial review. What transcript? Oh, the transcript cited herein. Sorry. Except you have made no mention to a transcript until now. This is your first citation of a transcript. You've made allegations of what was said in the video. You haven't mentioned a transcript until now. You certainly haven't included a transcript, but yeah. I wonder if he's figured out what metadata means yet. I have my doubts. Plaintiff is prepared to submit the video and full transcript for judicial review. The reputational harm from these broadcasts has inflicted untapped earnings loss. Many viewers influenced by these statements will never engage with plaintiff's work again. Frankly, anyone who listens to, well, maybe coming from Josh and Lackluster, but at least from Kate, any of Kate's viewers who were impacted with it weren't watching Delete Lawz in the first place. Like, any of them that were already watching him kept watching him as a lol cow. And the fact that he gained hundreds of thousands of subscribers right after, or yeah, I 100% believe that he bought the vast majority of those subscribers. That's my opinion. Delete Lawz, Decastro, Jose, Chili. That's my opinion. Opinion is protected speech. But assuming he bought those subscribers, he shot himself in the foot. He disproved his harm. Well, yeah, I was harmed, and no one would dare watch my videos after hearing that, but I gained hundreds of thousands of subscribers right after. But it would have been millions. So dumb. So the damage is ongoing, cumulative, and devastating to plaintiffs' potential reach, credibility, and future revenue. You not knowing what you're talking about is the damage to your credibility. Your potential reach and future revenue, frankly, you're boring. You're boring. As I said at the beginning, I'm convinced the reason he sued now is, well, number one, to inflict further harm on his enemies, but also because he's irrelevant. He's irrelevant, and he's trying to grab that relevance back through the court. Yeah. The half-life of the lol cow is very short. That's why figures like Vitali and Johnny Somali and Jack Doherty and whoever else, they keep escalating in the vileness of their behavior because you keep doing the same thing. You keep being the same kind of jackass, and you're going to have a real short shelf life. Your lol cow half-life is going to be very short. So someone like Johnny Somali, I can't believe I'm about to say this. I really can't believe I'm about to say these words. Johnny Somali is smart enough to realize that in order to stay relevant and keep the views coming in, he has to escalate his behavior. He has to get worse. He has to get more offensive. He has to get more controversial. If he stays the same, people stop talking about him. If he does worse, people keep talking about him. New people start talking about him. Frankly, Legal Mindset has made a lot of money talking about him. I don't know Korean law at all, which is the big reason I haven't talked about him. But yeah, 400 out of 500,000, that's abysmal. I mean, I realize I'm small potatoes, but on YouTube, I have 32 out of 2,200 at pushing midnight on the East Coast. I mean, I'm as irrelevant as I am. It's at a bad time, it's a bigger proportion. And that's such a horrible thing to say. I absolutely hate in any way saying Johnny Somali is smarter than anyone. But in this case, Chili is that dumb. Semi-skimmed or full skimmed milk from a lol cow. I think you get rancid curds from a lol cow. Like, but I'm not a lol cow botanist, so I don't actually know. But either way, claims for relief. Count 1, defamation against all defendants. Plaintiff realleges all preceding paragraphs. Defendants published false and defamatory statements of fact regarding plaintiff. These statements were made with actual malice and harmed plaintiff's reputation. Count 2, false light against defendants. Blah, blah, blah. Defendants publicly cast plaintiff in a false light that would be highly offensive to a reasonable person. These false impressions were conveyed to millions of viewers and caused severe reputational harm. You're just reciting the elements of the cause of action. I mean, that's the big thing. Their time is finished. They don't realize COVID is over. Jails are accepting prisoners. You can't go out and harass people with impunity like you could in 2020 and 2021. The jails are open. So they're completely irrelevant because they, in order to get views, they have to escalate Johnny Somali style. They do that, they go to jail. Because even the stuff they were doing during COVID, it's not going to get the views anymore. It's boring. It's been done. So they've got to escalate, but the stuff they were doing in COVID would get them in jail now, since COVID is over. But that wouldn't even be enough to get them views, so they'd have to escalate, and hey, now you're looking at big jail time. Congratulations, you played yourself. So prayer for relief, and I keep scrolling down, but I don't want to because he puts his address on there for some reason, and I do try not to show his address, even though he doesn't live there. Well, he might be living there. I'm assuming it's still a mailing address, but claims for prayer for relief. Wherefore, plaintiff respectfully requests that this court A, award compensatory damages in the amount of $1 million, divided as 1, $400,000 for reputational harm and loss of professional opportunity, 2, $300,000 for emotional distress, and 3, $300,000 for general damages related to public stigma and future earnings loss. B, award punitive damages for willful and malicious conduct. C, award costs and pro se legal fees at $400 an hour for research, drafting, and filing. Bitch, please, you... Okay. Pro ses do not get legal fees. You are not a lawyer. You do not get paid as a lawyer. You do not get legal fees. Aside from that, if I filed this and I went to the court and said, Judge, due to legal fee shifting statutes, I put a lot of hours into this, and I think the defendant should pay me $400 an hour for this. That, like, no. If a lawyer tried charging $400 an hour for this, and then received a bar complaint, the bar wouldn't just tear them a new asshole. They'd tear the third, fourth, and fifth assholes in the process. This isn't $20 an hour legal work, let alone $400. And I was going to shout you out for it, Corrosive. I just hadn't gotten to it yet, because I did remember you mentioned it. But good God, that like, if I were to write a book about this, it would be Chili Decastro and the audacity of this bitch. $400 an hour. $400 an hour. Like, no. No. Even if he could collect. No. Jesus. Dated May 27th, 2025. Respectfully submitted, Jose Decastro, blah, blah, blah. Still with, what's his name's address? Can't remember his name. Was it Scott Condon that he lived with in Malibu? Either way. And then we have the redacted declaration. To be crystal clear, Chili never asked or demanded that I leave my home, nor did I stay in a hotel, blah, blah, blah. It's just such nonsense. And then we have the declaration of redacted witness for protection, or redacted for witness protection. Just all such complete nonsense. It's not even worth going through these, because it's all nonsense. It's all irrelevant. It's all improperly filed, improperly attached. That's it, David Condon. I think I went to junior high with a guy named Scott Condon way back in the mists of time. That's probably where I pulled that out. Yeah. I mean, like, Lackluster, according to him, Lackluster has 1 million subs, and Josh, several 100,000. Like, they might have the views. Of course, if Lackluster has 1 million subs and, Delete Lawz type views, probably not. And what kind of views does he get? Does he get short views? Are they live streams? Are they edited videos? But, Kate doesn't have it. Like, I just, is he gonna try to bring Google into this again on his inevitable amended complaint? But and that's what I meant, is if he has 1 million subs, he could have $1 million, you know. You'd think with 1 million subs, you bring in a pretty good income. And so, you know, it's possible that Lackluster has $1 million to pay in the judgment. I have no idea. But it doesn't matter because he's not going to pay anything in a judgment because there's not going to be a judgment. So, you know, over here, what's going to happen? Well, it's possible that nothing happens because it's entirely possible that they all just ignore it. What's he going to do? Get a default judgment? Well, we don't have a sum certain, so then he's going to have to prove damages. He can't prove damages. I mean, that's the game that, frankly, everyone but Blue Bacon have been playing in the LA case. So, you know, of course, it hasn't gotten to the point of him even trying to prove damages since Blue Bacon has been fighting the case, putting it on hold for everyone else. But, like, I have my doubts that Kate responds. I have my doubt that Josh responds. Lackluster, I have no idea. Like I said, I've never watched him. I have no idea. It's possible. But if any of them respond, we are going to have our good old friend Rule 12B. We are going to have a 12B1, motion to dismiss for lack of subject matter jurisdiction. There is no subject matter jurisdiction. And that's it. He's defamation proof. He's 100% defamation proof. His own actions have given him such a terrible reputation all on its own that he's defamation proof. But we're going to have a 12B1, motion to dismiss for lack of subject matter jurisdiction, because as I mentioned, scroll, we have, you know, his jurisdictional argument is, hey, Massachusetts General Laws, Chapter 223 and 223A, as opposed to Title 28, Section 1332. So there is not subject matter jurisdiction. Oh, no, you know he hasn't paid a penny. He'll never pay. So 12B1 and also our good friend 12B6 motion. We'll have a motion to dismiss for failure to state a claim upon which relief can be granted. That's presumably based on statute of limitations. I mean, there are other arguments that can be made, but the easiest one at this point, at least for Josh and Dale Lackluster, is statute of limitations. Motion to dismiss for failure to state a claim upon which relief can be granted, because relief cannot be granted on a claim made after the statute of limitations. See how that works? But then, you know, we also have our good friends, Twombly and Iqbal. The dumb is rubbing off on me. I had to think for a minute. Remember our friends Twombly and Iqbal that we have mentioned pretty much on every lawsuit we have done, and those are basically they are, you can't just plead generalities. You can't just bare recitations of the elements of the cause of action. conclusory statements. You have to prove, you have to make factual allegations, and he's failed. He's failed. That's the shorthand to refer to both of them, Twickball. So you know, motion to dismiss for Twickball 12v6, motion to dismiss for statute of limitations 12v6, motion to dismiss for, frankly, you can't answer a complaint that is as vague as this. As far as Kate is concerned, she doesn't know what she's defending, so relief can't be granted. That would also be under Twickball, though, frankly. And 12b1 plus possibly res judicata, collateral estoppel, blah blah blah, should have brought this with other claims, although I don't think that disqualifies necessarily unless the court views it as a continuous series of events that should have all been brought. But in my short view, I didn't see mandatory joinder of claims, just mandatory joinder of parties, but it's all, yeah. Couldn't remember, but either way, generally it's not an issue because lawyers don't play fuck shit. We just, we bring all our claims. We don't leave one in the bank in case we lose so that we can then sue again. That's frankly, that would be malpractice. It's not what we do. So, and Goosebump, I was aware that Laura Owens had been charged. I haven't done anything to follow it. So I don't actually know anything about the case other than that she was charged, and the body cam is probably golden, but I have no details. She deserves everything coming her way. Frankly, that's what I'm referring to as far as what I had heard would make the body cam glorious. So, yeah. But I have a feeling we're obviously one step closer to at least Massachusetts federal court declaring him a vexatious litigant. That only applies in Massachusetts, but he's a step closer. Does this get him over the line? Probably not, but it could. And so I mentioned this at the very beginning. As I said at the end of the first Karen Reed trial, I would not cover it, but at the time I thought I might watch it, but not cover it. I have done my best to avoid it because once was enough. That was a lot to sit through, and I am very happy with my decision to very much avoid it. I mean, other than the Karen Reed page in the Masshole Discord, and I'm not even, I don't read through that every day, especially early in the trial. I didn't. I have more the past week or so, but I've avoided it. I have not seen 1 minute of that trial, and I'm happy that way. But so what else do we have? That is my understanding. That is my understanding. Not that YouTube would have anyone know it, but that is my understanding. But yeah, so there are a few things possibly in the works, and let's pull this over here. So there are a few cases that I might cover. Obviously, I do need to get caught up on Janet versus the Girlies. I do need to get caught up on the TikTok psychic, Schofield versus Giard, because Giard does not give up on the crazy. She never will. I have been intending to cover, basically do a reaction video on Wendigoon. Wendigoon, big multi-million subscriber YouTuber, did a video talking about sovereign citizens. I have not watched it. I'm going to do a reaction to it. I just haven't gotten around to it. And so that is coming down the pipeline very soon. How many of you remember Private Attorney General Anthony Troy Williams? Because Paul Berry sent me an absolute gold, like just absolutely amazing federal lawsuit involving Anthony Troy Williams. And you'll never guess who the defendant is in the case. Who Anthony Troy Williams is suing. Mr. Private Attorney General himself. Genius that he is. And then in looking for it again, there's actually also a pretty funny habeas corpus petition he filed since he's in prison. But there are a few other things I've thought about covering. I'm behind on this one anyways, because frankly, I found out about it after way after it was filed. But we have Drake suing Universal Music Group. I bet you can guess what Drake is unhappy with Universal Music Group for. Yeah, it's probably Kendrick Lamar that he's unhappy about. Although this complaint is so long. It's like 100 pages. Of course, lots of it is tweets and pictures and stuff. So that does take up a lot of real estate. But there's that. Let's see. Can't remember what Doe versus... Oh! Doe versus NFL. Yeah, we've got to do this one. We've got to do this one. So, I am just giving a road ahead at this point. The Delete Lawz coverage is over. But as most of you know, I am a University of Utah fan. Doe versus NFL is some idiot fan of Shedeur Sanders claims antitrust violations against the NFL because Shedeur Sanders fell to the 5th round in the NFL draft. That's going to be a one and done video, but it's pretty hilarious. And as those of you who follow college football may be aware, when Utah and Colorado both joined the Pac-12, RIP, back in 2010 or 2012, thereabouts, because we both left the conferences that contained our historic rivals. Frankly, Colorado's had left before because Nebraska went to the Big Ten, and they are Colorado's rival. But Utah left BYU behind in the Mountain West Conference. And so Utah and Colorado became de facto rivals, which it didn't quite have the same ring as Utah versus BYU, but just the same, Shedeur Sanders playing for my school's rival, I can talk about it without being labeled a hater, just a rival, even though I'm a hater. But yeah, that's a one and done for obvious reasons. But that one will be fun. I do need to get caught up on Braun versus Day. That's one of the Sean Combs lawsuits. Don't need to do that. What's Doe versus Bunnell? Stephen K. Bunnell. Let's see. Oh, that's the Destiny lawsuit. Okay, that's right. That's right. So Destiny was sued for improprieties back in February, and there are now 89 docket items. Let's see. Oh, that's nothing. Well, I don't think that's anything I want to cover. A Disney lawsuit. Oh. If I remember, that was an interesting one. I've got a lot of tabs open of things that, ooh, I want to cover that, and then I'm lazy and don't cover. So yeah, going forward, if you want to watch me lose my shit to any of these, let me know. Because, if you say, yeah, I'd watch that, that gives me more motivation to cover it. Because, doing something I'm interested in, but then not getting views removes my motivation to cover a subject, even if I'm interested in it. Because I then figure, well, you guys aren't interested in it. So if you are interested, let me know. And that's my understanding too. And I'm not the least bit surprised that that's what teams, thought of him, because frankly, he is obnoxious. He is conceited. And frankly, I don't think he's all that good. That's Sanders. But yeah, so those are the potential lawsuits that I have found. I know there are others. So if there are others, tell me about them and we can look at them. And because I know I've said this each of the last couple videos I've done and then not followed through, but I do intend to stream more regularly. And when I say streaming, that includes both actual live streams and uploaded videos. And I do intend, I've got a body cam channel in the making. I just haven't done anything with it yet, but partly because I haven't had the money to request body cams for it yet, but I do want to do things with it. So yeah. And send that to me so I will remember, Goosebump. Because I will forget. I always forget to mention this, and I hate that the link expires, but I did put the link to my Discord that has no members in it except for me, because the link expires and I always forget to mention it. But I do have a Discord, technically. I did put a refreshed link in this video description. I need to remember to put it on my YouTube about page, but I do have a Discord if any of you are interested. That is an easy way to get a hold of me. I do also have my email on my YouTube page. And so, tell me if there's a video you want me to do, if there's a lawsuit you want me to do. I can only do it if you tell me to. And yeah. So what's that one? I don't even remember half of these that I have opened. Tilleman versus Hildebrand. Oh, that's Jody Hildebrand. Okay. One of her victims suing her. Yeah. Yep, it's like rugby, but with costumes. So, all right. Well, it's midnight on the East Coast, 10 o'clock here. It is, yeah. That could be all I do of this. I like I said, I'm done. I'm done with Delete Lawz. So if it tickles my fancy, I might do more updates on it. That's if if further filings are amusing. But if I'm not amused, this could just be a one and done as well. Just letting you know ahead of time before you get too invested, because he's not interesting. So that said, thanks for joining me. I know it's been a long time, but do the YouTube-y things, like, share, subscribe, bribe your friends and family to do the same, and I will see you soon, hopefully much sooner than it has been, for the next one. Find the end stream button, since restream is weird. Bye-bye.